absentees. I said that because they're in a different box of precincts. But we're actually going to literally have to go in each precinct box and find certain portions to support the petition. And if you say the clerk's going to make it available,
spend all that time when you canvass it and you don't know which precinct box or what you're contesting.
we know exactly what's in each precinct box and exactly what we're contesting, and we know exactly which voter and what name and what document. I'm just telling you that I'm not certain that they're put back in that precinct box. And so I'm well glad to go ahead and designate with great specificity what documents we are looking for in what boxes. And if they're not there, I would ask that the clerk be allowed or directed to allow us to go into the other boxes to search for those documents if they're not where they're supposed to be.
Make the order broader enough. If what you're looking for is a certain precinct box is not there, then you will have access to any of the precinct box that you desire, even if it means all of them.
Thank you.
Now, on the
Your Honor, should I include, excuse me, I'm sorry, just because we're moving so quickly on this, should I include in the order a specific time so we can go ahead and really be ready to that this week?
I think it should be this week, which is I know you're asking for.
We have one other person that we need to consult with, but I'd like to go ahead and present the order to Your Honor and have that scheduled this week as soon as possible. And I can let the clerk know, I'll get with the city clerk and work out their schedule. Maybe do it within a couple of days.
Okay. Thank you.
All right.
You, let me relax you further. Since I broke my computer, I have tried to use my iPhone, but I have not. I have no idea how the proper connection would be from my iPhone to my printer. It has to be furnished. All orders have to be furnished too, because I cannot print them.
I understand. So Your Honor, just so I'm clear about that, we should have the orders brought to you by hand as opposed to trying to communicate with you through the internet.
Yes, but check with me by phone before we come out.
We will do that.
All right. And another thing I might bring up is, Ware, you have my phone address instead of my present address. I don't want to give it to you at the present time. I'll have it. You may check with the court administrator. She'll furnish you with my correct address.
Thank you, Your Honor.
Thank you.
Just one point of clarity, trying to understand something Council Officer was talking about. He was talking about certain things as if he was representing the city of Hattiesburg. I just want to make sure I'm clear about that. They're not representing the city, they're just representing Mayor Dupree.
Yes.
I'm here to represent the elected commissioners, Your Honor, which is an appointed board by the city of Hattiesburg.
Identify yourself. please.
Charles Lawrence, Your Honor.
John White.
Lawrence. Charles is the first name.
And let me know if I don't follow you. You want to be heard on.
So far, I haven't had anything to say.
Now, as to the video, can you designate that by time limitation?
Yes, we can designate that with specificity so that we very
It would
clear.
be preserved if it has not already been preserved.
Right. Thank you. We actually have some orders here that we've already prepared. Would you like to wait to the end of the hearing to present same?
Yes, wait till the end of the
All right.
Okay. You have any other motions?
Your Honor, this time we don't have any other motions other than now that I know that the Election Commission has counsel present. We actually think, and we'll present you with a case, that the Election Commission is not required to be a party in this case. Once they have certified the election, at this point, the contest is purely between Mayor Dupree and Mr. Ware.
Well, you brought them in.
I understand that, Your Honor. We did that out of abundance of caution, just as we went ahead and followed both counties, because the statute requires you to file it where the irregularities occur. So we will submit that to you separately for the court to consider. Thank you, Your Honor.
You want to be heard, Mr. Martin?
Well, the election commission can speak for themselves, but you're right, they did sue the election commission. We do have a motion to be heard, Your Honor.
I understand you,
Okay.
but I'm trying to get this to come to it.
Yeah.
Mr. Lawrence, you want to be heard on this? I guess a motion, is a motion to dismiss.
Well, certainly it has to be a motion made by both defendants, Your Honor. I mean, both plaintiffs, as the election commission was named by both plaintiffs.
I'll get to that.
That's all that I would have.
You wish to be heard? Thank you. Fresh in order. And I believe we're moving to your motion.
Your Honor, my co-counsel Brandon Jones is going to be making an
Brandon Jones.
yes, the DA's law firm, not Jackson's.
Please.
And please the court, I am Brandon Jones, co-counsel of Mr. Martin here, representing Mayor Johnny Dupree. Your Honor, as you know, we bring a motion for a more definite statement under Rules 12B and 9B. I think it's notable that a moment ago, the plaintiff's counsel said something like, we would like to find information that may lead to information. I think that's a good early theme for the papers that have been filed by the plaintiff to this point. In both their initial petition and in their follow-up motions, we see a glaring lack of specificity. And even though we do have relaxed rules regarding the way that we have to plead things in the state of Mississippi, there's no question that we do have some guidelines through the rules. And so we would direct the court's attention to Rule 12E, which talks about the need for a more definite statement in those instances where a petition is so vague and ambiguous that a party who it is served upon cannot even begin to fashion a response. And also because so much of the overtures made by plaintiff and the overtures made in the papers that have been filed seem to suggest that plaintiff may try to convert what these allegations are into a fraud type complaint at some later time. We do think that 9B does have a bearing in how this petition should be considered by the court and read prior to the time that we enter our answer. Now, by way of specificity, Your Honor, there are several items we would point the court's attention to. Most notably, there is at no point in the petition that has been filed any effort made whatsoever to explain which allegations apply to which defendant. Now, this could potentially be cleared up by the motion that was just orally brought before the court to drop the election commission. But it is
If they release the election commission, that's only one thing.
and then that's what I was anticipating. That would certainly make a difference here. But there's some other instances, and let's take a look at those. Paragraph 13 is an instance where we hear about a train depot voter who apparently voted by absentee in the presence of the clerk. And what plaintiff says is that ballot cannot be found. There's no allegation of wrongful conduct, and we've just learned that from plaintiff's counsel that they can give you names, serial number, all the verifiable information. We would simply ask that in these instances where potential alleged acts have taken place, that we have that underlying information and we have an allegation. The train depot is a good start. That's paragraph 13. Paragraph 14 begins the assault on the voting that took place at Forest County Detention Center. And here you have what appears to be an allegation that of those 36 absentee ballots that were filed there lawfully at Forest County Detention Center, that they were witnessed on May 24th, all witnessed on the same day, that they were witnessed by the same person, and that the folks who voted by absentee ballot on that day changed their reasons for voting. Again, this is one of those paragraphs that begs what exactly the allegation is. Continuing in the following paragraph, paragraph 15, we have a long paragraph, a long diatribe about the fact that the person who signed off on those ballots, both the ballots and the applications, that it was signed by a single notary, and the complaint appears to be that the person wasn't there long enough at the prison there to sign the affidavit affidavit, the absentee ballots, to notarize the absentee ballots. And so that again is a matter of opinion and not really anything legal that the defendant knows how to answer. Paragraph 16 talks about 5 votes cast by illegally disenfranchised felons, and then goes on to say that there were certainly, on information and belief, words that occurred throughout the petition. We're told that there were other votes cast by disenfranchised felons, although we're not directed to a precinct, we're not given any names, and so it stands to reason that the entire voting public is under this umbrella of suspicion based on the plaintiff's petition. In paragraph 26, we're referred to 4 affidavit ballots that were allegedly counted even though the voters were from different precincts. We're not told which precincts, we're not told which voters. There again, this is shotgun blanket proceedings, petition in search of information, information in search of information. Paragraph 28 is what we believe a test case in shotgun pleading. First, it begins by restating these mystery felons and how there must have been dozens, who knows how many, that voted in this race. No specifics, no underlying allegation, not even a precinct. Then we're told about a Facebook post that the plaintiff found suspicious. Then we're told about a voter's residence that was allegedly destroyed. Then we're told about a residence where a family member apparently told someone that that person no longer lived in Hattiesburg. Later, we're directed again to the plight of the unauthorized person in City Hall. No identification is given, so we frankly are not sure how the plaintiff arrived at the conclusion that this person wasn't authorized if they don't know who they were. And then we're told about 55 minutes of video footage that is missing, but we don't even know that that 55 minutes ever existed. And again, as Your Honor has already mentioned, we do need a time limit there, because again, we're riding the line, as we are throughout this point. Later, we have an allegation that the clerk, the deputy clerks, and the poll managers were not properly appointed to serve and to do their duties in this race. Moving forward, Your Honor, we have paragraph 29. This is another series of blanket allegations regarding alleged episodes of improper voter assistance, intimidation, or interference. No reference to the law that was violated, no reference to the underlying individuals that were involved. Again, while we do get precinct information here, which is appreciated, we don't have enough specifics that we believe 9B requires, and that's even anticipated by other parts of the rules, in order to fashion a response. Again, Your Honor, moving forward, in paragraph 31, another information and belief paragraph says that several voter machines were not calibrated or tested for logic or accuracy. Again, we don't know what the underlying basis for that charge is or what precise standard they didn't live up to at that moment, making it very difficult to understand precisely how to answer. Now, again, we don't want to overstate what the rules of civil procedure say. There's no question that we have liberal pleadings in the state of Mississippi. But even the case law that plays out Rule 8A does say that at a minimum, the plaintiff must address all of the elements of the cause of action necessary to sustain recovery. And in the paragraphs just mentioned to the court and detailed in our brief, and really throughout this petition, we find instances replete of these facts, figures, conclusory paragraphs without any real connection to what the underlying law is that's alleged to be violated and how those facts stack up to the elements that would be required in order for the petitioner to be successful. And so what we would simply ask the court is that the court issue an order that would require the plaintiff to fashion a complaint or a petition that would enable the defendant to form an answer so that it would be clear what exactly is being alleged, which pieces of this that the defendant can even answer for. Thank you, Your Honor. Yeah, well, Your Honor, it was filed shortly after those 4 came across on the internet on Friday. We filed it Friday night on the internet, which I understand has been an issue, and then dropped it in the mail at the same time.
that. I really don't. I don't have. I had it so. I think Bert filed up today.
We'll be happy to drop one off today if that's preferred. Okay.
Have you been furnished with copies of those? Excuse me.
Your Honor, before I respond to this, just as a housekeeping matter, just as a matter of making it clear, we have no response to the petition itself. I realize that they have filed this petition for a motion for a more definite statement, but we have no response, and we would hope that you would allow us to go ahead and include in the order deadline for them to respond to the petition. But let me speak to the motion itself in a more definite statement. An election contest is actually much different from any other type of case. The proceeding is, as you said, very much expedited, and there are cases that talk about what you're supposed to plead and how you're supposed to plead. And they don't talk about the rules of civil procedure. In fact, they talk about you shall plead with specificity, okay? If you look at our petition, and I believe that you have, you'll see that it is 17 pages, not counting the attachments, many pages of which are single-spaced paragraphs. We literally wrote a book on this question. They are exactly correct. We did not list the names of the people. We did not list the names of the precincts. We did not list the names of the individual statutes because that's something that we would put on proof about. And we understand and we welcome the burden that we have of placing the proof before the court to be able to substantiate each and every one of these allegations that are material to our case.
Well, without knowing in specifics what you're going to put on, how can they prepare for things?
If it is the will of the court for us to go ahead and specifically name names,